So, good morning. So, the following are the role 119, the lesson that I've learned in role 119. So, trial is the examination. This is the termination of the truth in order to resolve a case, resolve an issue in a particular case. So, after after a plea of not guilty, he or she entered, the accused shall have at least 15 days to prepare for trial, and the trial shall commence within 30 days from receipt of pre-trial order. So, trial is to to prove beyond reasonable doubt. So, procedure of trial is uh, the trial once commenced shall uh, continue from day as today for for as practicable until terminated. So it may be postponed for a reasonable period of time for good causes, good cause. So trial, the purpose of trial is to, the purpose of continuous trial is to, uh, the purpose of continuous trial is to, uh, in order of trial in criminal case. So uh, first is to, uh, criminal cases, the prosecution shall present the evidence to prove the charge and the charge and the proper case and the civil liability. Second is to, second is the accused may present the evidence to prove his defense, any any arising from the issuance of a provisional remedy and a provisional remedy in the case. Then third is the, uh, after the prosecution and the defense presented the evidence, so then then they can present the rebuttal and so rebuttal. They can present the rebuttal and so rebuttal evidence. Then fourth is to, the case is deemed submitted for a judgment. Then rebuttal and so rebuttal is to, rebuttal and so rebuttal evidence are evidence which will uh, controvert the evidence presented by the prosecution and uh, and the defense, and at the defense in and the defense at first instance. So right, and the opportunity to produce additional evidence. So the the judge is not, if not satisfied with the evidence produced and criminal cases, he uh, he he may he may or his motion call a witness. So case them submitted for decision. Uh, Case them submitted for a decision as upon this admission of the evidence in chief rebuttal. So rebuttal prove as the case, maybe the case is submitted for decision or judgment. Then uh, instances when the presence of the accused required by law, so first is the uh, first is arraignment and arraignment and entering plea. Second is uh, during trial, when his presence is necessary for the purpose of identification. Third is to upon promulgation of judgment, except for the light offenses. So, and four is to when the court with due notice required so with due notice required, so then time limit for the trial or criminal cases is to trial shall not exceed trial shall exceed 180 days from the first day of trial, except those cases governed by the rules of summary procedure. There's those penalty prescribed by law does not exceed 6 months.